Good afternoon.
Hello.
Hi,
Hi, Miss Archer.
how are you?
Good, and you?
I'm fine. Where's the rest of the class?
JL said she's running a bit late. She decided to do something with her sister, so she should be on like a short.
Okay. But nobody else is on. I know everybody is all somber because of the new requirements beginning on Monday.
Yeah.
Yeah, because I think if you listen to Rodney Monka, he's anticipating that it may be even more next week. That's what he said. You know, he always do some scare tactic.
Yeah, I stopped listening. I don't know.
I just listen because it's be good jokes.
Yeah, that's the only thing.
Yeah, the jokes are good, so I
Yeah.
listen for the jokes, but nothing to do with common sense. Just
That's
jokes.
I
Just
agree.
jokes. Just jokes. That's it.
Yeah, that's only jokes.
Only to get the jokes. He said he's going to get vaccinated now.
Oh, really?
So yes, he said he's going to do it now because of
The Delta variant, eh?
the Delta variant is most likely here.
Yeah.
I think, yeah, he said that the nurses have said that the people are coming in on the gurneys, they're not walking in, and they're having
no.
chest problems. So that sounds like the
Rough.
Delta variant. So he said he think
Yeah.
he's gonna go and get it. So Wayne
Uh,
Monroe say, as soon as you get yours, I'll get mine.
They're clowns.
Yeah.
Clowns.
So
Yeah,
I think it's just for jokes.
that's all. Have you been vaccinated?
Oh yes.
Oh, I probably want to go next week or a week after.
What you waiting on?
I know when I tried to make an appointment the other day, it wasn't giving you any dates.
Oh, I think they were waiting on supplies.
Yeah, so I want to look back at that and see.
Yeah, that's why I did mine early. I
How did you
figured that,
feel?
no problems.
Good. Okay.
None.
Yeah.
Yeah. Only thing you do is you take your Panadol.
Right.
Take your Panadol. You could take it from the night before if you forget. You take it before you walk in or just as soon as you walk out.
Right.
Yeah, don't wait till you get home. Take another one in the afternoon and take one before you go to bed. And it depends on how you feel. You take one in the morning because some people get the flu-like symptoms.
Yes.
But if you take your Panadol, it shouldn't be that bad.
Yeah. Okay.
That's all you have to do. But
There's
other than that,
a lot of people on social media just trying to distract people and scare people with tactic. I don't know.
yeah, but you see, the thing about it is that if you listen to them and they have that so green and people are dying.
Yes. They don't see the seriousness of it.
No. And I think now that they see when they started calling from the morgue to say they had 220 bodies to be collected, people begin to see, yes. People begin to say, oh God, this is really serious. So you're looking at a 32-page every week of dead people, and there's still 220 unclaimed in the morgue.
Wow.
That's a lot of people.
It's a lot. Yeah. They don't get the seriousness of it. And it isn't about politics either. Come on, leave it out.
No.
Oh man.
No, it's not. And what was so funny with Rodney Monka yesterday was he was saying, he said, listening to the measures that the prime minister has put in, they're not right. Curfew should start from 5 o'clock or 6 o'clock. And I'm saying, okay. So when it first started, that is what he started to do. Everybody pick up.
You see
Replace
that?
him. Replace him. What is he trying to do? Now that
Mhm.
they see people dropping down dead all over the place
Yes.
every minute of the day, they now want him to go back to where he was.
You see that, Miss Archer?
Yes.
Boy, you can't
I say,
please us.
boy. I say, these people,
Hey, you're damn
mm-mm.
if you do and you're damn if you don't.
Exactly. I say, these people, they'll cause you lose your mind. You don't listen to them.
Yeah.
Do what you
Yeah.
have to do.
Yeah. But even the
Just
state
do.
is on an uptick.
Oh, listen. I
Uh,
was in Miami. What this week is?
um,
What the day is? Saturday?
this is
Oh,
yeah.
I just came back. I just came. The
What?
days just go so fast. I have to look at the
Yeah.
calendar. So I left Monday. I came back Wednesday. And when we got there, we just drive around to see, how things are. Well, everything
Right.
closes between 10 and 11 o'clock. There's nothing
Oh,
open.
really?
Oh, yes.
Uh-huh.
And it looks as if people only who have something to lose are wearing
Yes.
masks. A lot of people don't wear masks.
Right.
And not until they came on with the news on Tuesday morning, Jackson Memorial Hospital say that no one is allowed to come and visit the people. There's no more capacity in the hospital. The people are dying at an alarming rate. We say, so why are these people walking around without masks?
Goodness. It's crazy.
Yes, because they have the Delta variant there and the people are dying.
Exactly. Exactly. So they close at 11 in the night?
Yeah, they closed. Everything is closed.
So why they carry on so bad over here? Because he said,
I don't know. You see, if you don't go, you wouldn't know.
Yeah, yeah.
And another thing is that a lot of the stores, they don't have sanitizers and no one is there telling you to sanitize your hand,
Say what?
No,
No,
I'm sorry for you if you don't have none in your bag. God help you.
I can't believe it. So we are a step above.
I'm telling you, you see how people are cleaning down in the bank behind you, and it's none of that happening.
Oh man, well they looking to have cases rise.
Yeah, well they don't have that. Everybody just doing what they feel like doing. No,
Boy,
it
them
ain't.
people,
Yeah,
and them
No,
people
it
in
ain't.
Tokyo, they protest and they don't want no Olympics. They were saying that from before it started.
Yeah, but I don't think they should have it.
Yeah, I don't think they should have had it either.
No, I don't think so. I don't think so. Because you see how people are now being disheartened because they went there, caught it, and now they can't perform.
They can't
and they have to
perform.
wait. Yeah. It's just not, it ain't good. Not at all.
It's the time, eh?
Yeah. Anyhow, let's get started because it's being recorded anyhow.
Oh, yes.
Yeah.
Only me and you.
So once a year, it's just you and I, but it's being recorded, so it's just as good.
Okay.
So last week we did shares, which was quite an interesting class. We got through a lot. So today we're going to look at company management.
Okay.
And right. So company management is looking at directors and shareholders and how they interact with each other. And this stems also from looking at the shareholders agreement. So whenever you form a company, especially if it's a public company, you have the shareholders are able to come in and they're able to say or give comments or things that they want added to the agenda. But more importantly, when it is a private company, it is always best to have a shareholders agreement. And the shareholders agreement would speak to when there are issues between the shareholders, what should be done. If the shareholders were to die, what needs to be done. If the shareholders wanted to sell their shares, what can be done? Now, of course, you can have these things included in the articles of association.
Right.
But it's always good to put things that would happen in a dispute in a shareholders agreement. And that's the reference document that you go to.
Ms. Archer, in the shareholders agreement, that lessens or takes away the director's duties, right?
You can put provisions in there.
Okay, okay,
You can do that also. If you don't
Okay.
want the board to have a certain amount of control, you can also put those provisions in the shareholders agreement.
okay.
Yeah. So I would have sent you all a document last week with reference to the shareholders agreement. I don't know if you saw it.
Yeah,
Yeah.
I'm looking at.
Okay, take your time and read that document, because that document speaks to what are the common provisions that should be in a shareholders agreement.
Okay.
So if you have it handy, I don't know if you have it handy.
Which I know you sent 3, so which one?
This one's called the shareholders agreement, and it's prepared by Stevenson's law firm. It has like a shadow with two gentlemen shaking hands. See if you see it. I know I sent it last class. Let me go to my sent box.
Yeah, you sent it. I trying to figure out which one. 3.
I think it would say Stevenson's. I don't have the thing on here. Let me see. Saturday last week. Okay, let's see. Oh, I sent you all plenty emails. Hey,
Yeah, you said.
all I can tell you right now, those were the questions, though. I sent you all. some
Okay.
doc-
Yeah,
see
the
it?
Stevenson's. Yeah.
Right, that one. Okay. So the first thing it says is, the shareholders agreement, it regulates the relationship between the shareholders and the management of the company, the ownership of shares, and the protection of the shareholders.
Mhm.
So it's 4 purposes. It regulates all that.
Okay.
And it combines the use of the shareholders agreement, is drafted along with the articles of association. And it's the document you go to if things go wrong. Because if a company is owned by 3 persons and there's a dispute between 2, and there is no document to say what happens in a dispute,
Right.
then you have a real problem. So you have each one pointing the finger at the other one, and each one saying they have this right and they have that right, but no agreement was made.
Right. Okay. And I know I've seen shareholders agreements filed with the registry.
So it says, in the absence of a shareholders agreement, it opens up the potential for disputes and disagreements between the shareholders. And that's what actually happens, because there is a disagreement between them, even in terms of what happens if I decide I want to sell my shares to a friend. And the other shareholder may say, well, I don't agree. But you never put an agreement in place as to stipulate as to who can buy the shares if one of the shareholders decide that they want to sell.
Okay.
So if you look on, I don't know if you can see the pages. Let me see if I can find the heading. They have what they call, you get an insurance policy, like if a shareholder dies.
Yeah.
And then when insurance pays off, the existing shareholders take the proceeds of the insurance policy to pay for the shares.
Oh.
Right. And so the executor of the deceased shareholder receives the funds from the life insurance policy, and then the other shareholders take the shares.
Okay.
Yeah. So each shareholder will take out a life insurance policy, and then what they do is they do a cross agreement. So in the event one of them dies and insurance pays off, those funds will pay for the shares. The shares come back to the company, and then the funds go to the executor of the deceased. And then also, like, if you wanted to, like I said, if you're living and you wanted to sell your shares, they can put in the shareholders agreement as to whether or not the existing shareholders get first preference and who they can sell it to.
Okay. Like a preemption, eh?
Yes,
Ah,
yes.
okay.
So that's why it's always good to have a shareholders agreement.
Yes.
And then the last 2 pages of that document that speaks to the common items that should be in a shareholder agreement or the articles of association. So that's a good document to read. You get an idea of the shareholders agreement and the limitations that can be placed on the directors. Because don't forget now, in a private company, the directors in some instances are also the shareholders.
Yes.
And so you can have a lot of issue when it comes to control. All right, so now let's look at company management. We know that companies are owned by shareholders or members, and we know that they are managed by directors. And the role of the directors is they carry out the strategic vision and the mandate and the corporate goals of the company. And normally the strategic vision is based upon the plan that the shareholders have for the company, what they envision. They have a company, they know what they're going to sell, but they're relying on management to set out the vision of how it's going to be done to get the returns that they're looking for.
Okay.
So, right. So the directors are appointed by the shareholders and they formally manage the company. They set the goals and then they discharge their responsibilities and making sure that all of the stakeholders are aware of what the company strategy is and where they're trying to go. Now, in historically, the manager's main focus was on the shareholders. But in today's world, managers and the board has to focus on stakeholders. And those stakeholders include not just the shareholders, but also the employees, the creditors, the regulators, the environmentalists. All of those persons now are part of the board in terms of when they manage.
Okay.
Okay. So according to the 2 acts, the Companies and the IBC Act, they don't define a director or only an officer of a company. And both, however, both acts reinforce the general fiduciary duties of a director to manage the company, to act honestly, in good faith, and in the best interest of the company, subject, of course, to a unanimous shareholder agreement and the memo and arts. So directors are required to exercise the duty of care, diligence, and skill that a reasonably prudent man would exercise in such a position. And you know that the duty of care is enshrined in the Companies Act. You know the section?
Not off the top of my head.
But it's there, you know that, right?
Yeah,
Duty of
yes.
care,
it's there.
section 81.
Yeah.
Section 81 in the Companies Act.
Yeah, duty of care.
So as fiduciary, because they have that duty of care, directors have a legal duty to act in good faith. They have a legal duty not to make a profit from their fiduciary position. They cannot place themselves in a position where their duties as directors conflict with their interests. And with that fiduciary duty, that's also enshrined in our law in the recent amendments. Remember when I think it was to do a couple classes.
Yeah.
When we're talking about the amendments that were passed in 2020 and 2021.
Yeah, with the seal and all that.
Yes, one is about all of the seals and the other one is where they made amendments for conflict of interest.
Okay.
And they're saying what a director cannot do in terms of having to disclose when they have interests.
Okay.
And when they fail to disclose, a shareholder can actually take the matter to court. Yes, they can.
Sue them.
Okay.
Okay.
So That duty of care in Section 81 of the Companies Act imposes on the directors a fiduciary duty. And always remember, when you see that word fiduciary, that means that in law, it is a legal duty.
Okay.
And that one, right, and that one word fiduciary means that they must always act in good faith. They must not make a profit. They can't put themselves in conflict with their interests. They have to act for their own benefit. They can't act for their own benefit. And they have to seek consent whenever it's necessary. They also have to act in accordance with the memo and arts. They have to make sure that they deal and they act with all the classes of shareholders equally and fairly. That is their fiduciary duty. So the first appointment of directors, as you know, is at the time of incorporation and is done by the subscribers. Subsequent directors are governed by the Articles of Association. And of course, the shareholders agreement, if it includes such provisions. The articles normally specify when and how a board may fill a vacancy for a director. Whether or not you can appoint additional directors and the maximum number of directors that a company can have.
Right.
So on appointment, a new director has to sign and signify that they consent to being a director. They have to sign a director service agreement. Make sure they have the relevant insurance and indemnities for the position. And then of course, the corporate secretary would provide a copy of the memo and arts, the details of the business, the latest financials, the recent board minutes, management accounts. And I guess you would give them a schedule of the statutory reporting requirements of the previous year, and then they could request which documents they want. In addition to that, you know, you also have the directors also have to provide all their KYC documentation.
Yes.
Right? And with that, you'll also get a copy of their resume, because what you need to do is on an annual basis, you do what you call a skills matrix to make sure that the director is meeting the requirements for the company. And when I say that, I mean that at the point in time in which a director was appointed, the skills that they personally have may have been what the company was looking for in order to move it in the direction it was going in. Over time, of course, that changes. And so you need to have the skills matrix and all of the educational background of the directors to make sure that the skill matrix matches up with the company. So normally there are two types of directors. You have executive director and you have a non-executive director. The executive director, as you know, works full-time and they're responsible for the day-to-day operations of the company. Now, a non-executive director, only thing that they do is they attend board meetings. And of course, they give advice to the board. So in the actual corporate law, there's no distinction between an executive and a non-executive. You're just a director.
Yes.
And they have the same legal duties, same responsibilities, same legal liabilities. And you know, an executive director is not paid any additional sum. He's just paid his salary. Yeah, he may probably get an additional bonus or something like that, but his salary is the same as any other executive in the company.
Okay.
So one of the first things you hear they always ask for when they are appointed as an executive director is they ask for the insurance to see what is their coverage and indemnification.
All that happens behind the scene, because I know I've never really dealt with that.
A corporate secretary would deal with that.
Yeah.
The corporate and legal secretary, they will deal with that.
Okay.
So in addition to an executive and non-executive, you have what you call nominee directors. And these personal or corporate directors and they're appointed to act as a director on behalf of another person. And they normally do that under a corporate management agreement or a nominee directors agreement. You also have a term known as shadow directors. And these are persons who operate by operation of law and is based on their conduct in relation to management and the decision-making of the company. And they are considered directors, and they can also be liable as a director, even though they're not formally appointed as directors. But what happens is that they act in a role, and it's based on their influence and the actual action that the board takes based upon what they say or do, that it can be interpreted that they are acting in the role as a director. So shadow directors has been encoded in our legislation in 2011, and in the Companies Act and in the IBC Act. They say that a shadow director is any person in association with those directors or instructions the directors of the company are accustomed to act, but the person is not deemed to be a shadow director by reason only that the directors act on advice given by him in a professional capacity. So that means that not because a person gives instructions makes them a shadow director. If a person or entity is considered to be a shadow director, he is liable for all legal obligations and liabilities of a director duly appointed or acting in the traditional sense.
Are shadow directors shown on the registers or no?
No.
Okay.
No. But when you read the minutes, you'll be able to tell if someone is acting in that capacity as a shadow director based upon what they say and what the board does.
I have to go and research that.
Is that in the case where under the minute they'll say, I'm giving power to someone else to execute documents on behalf of the company or something like that?
No. Power of attorney?
No. No, when that happens and someone's acting as an agent, no. I'm going to give you some cases. Okay. So in a lot of the English cases, they have indicated that the test as to whether a person or entity has real influence over the corporate affairs so as to be deemed as a shadow director is whether the real influence was wielded over the corporate governance of the company by the person or the entity identified as a director. If it can be shown that he acted on equal footings with the duly appointed or formal directors of the company. So the case is that you can read is quite a few of them, but you have the case of the Secretary of State for Trade and Industry versus Deverell. That's the first case.
Secretary of State.
You should find this on the internet. Secretary of State and Industry versus D as in David.
Yes.
E as in elephant. V as in very. ERELL.
Okay.
Secretary of State and Industry versus Deverell.
Okay.
If you key that in now, you should be able to find that. Let me know when you have it.
Some little stuff come up. But...
Little stuff? Let me know, because if not, I could send you my little paste up copy. Which is A little longer if you only see a little stuff.
I guess I just give you a snapshot of what it is. What I
Okay.
pulled up actually, yeah.
Okay. I have a longer shot. I have much longer than that.
Okay.
Let me- Hold on, let me get my paper. I have one here I could send to you so you can read it.
Okay.
I should use my email from last class so everybody can have it.
You know that Nathaniel is no longer with the class, right?
No, remember we asked about him last week?
Yeah, he messaged us yesterday, said he has to withdraw.
Why?
So his workload was I guess
Too much?
interfering. Yeah, he and who's the other one, Blair? Arniska?
Lolita?
Arniska?
This is Kate.
Who?
No, Arniska. That's the other one. Arniska. So that's two.
An-
We got two gone.
Aniska?
Yeah.
What Aniska last name was?
Um,
I don't know.
I don't know.
Okay, and Nathaniel.
Yeah.
And I think, hold on, let me see. The other person is,
Arniska was at Deltec.
what kind of workload they have so?
I don't know.
I don't understand. What's her name? Also can't make it back. Kristen.
Oh, really? Oh,
Yeah, she has COVID.
oh,
She and her husband have COVID.
wow.
Yeah.
So we
And
dwindled like down to nothing.
yeah, she said she and her husband have COVID, and so she hasn't been on for a while. And she says that they still have symptoms,
Wow.
and they're trying to get their children to come back home, but
Sorry,
they're not doing well.
Oh.
So that's 3 people there.
Yeah.
Yeah. That's 3 people. All right, let me see if I could get this for you.
The girl from Freeport too, was she named in that? She dropped out too, right?
Yeah.
Oh,
Curleen. That was the first one. Curleen.
oh yeah, Curleen.
First 4, right?
That's 4.
Yeah. Wow.
Mm-hmm. Yeah, Curleen dropped out. And I haven't heard from Makita. She has not been on for a while.
Yeah, I haven't heard of.
So maybe that's work again, eh?
Oh. Hope she's okay.
I hope so. I need to find out.
Mm.
Okay, let me see if I can find this case for you. So you can get to see. I don't like other stuff. What today is? The 20. Okay, so I'm looking for July.
24th?
Yeah, no, I saved it on the 23rd. Just in case you all couldn't get it, the 23rd. Okay. What is this here? Why this machine is doing what it feel like doing? Okay. Let me go here. I am going to save it again and see what it says. Save as. Okay. Okay, that's it there. Yes. Come back here and attach it so you can see Secretary of State versus Duval. Okay. So now I need to take out some of these people, right? Nathaniel, this one, and Anishka Ferguson, that's the name?
Yes.
From Delta?
Yeah.
Okay. So that should be everybody. Send. Okay, you should have it. Let me know when you receive it, so I'll know.
I received it. Give it on Blair.
Got it.
Yeah, you got it, Blair?
Yes, ma'am.
Okay, all right. At least with mine is a little bit more, right?
Yes, it is.
Okay,
Way
much
more.
more. If I say no, the minute I ask you to look this up, you'll say it's only just a little summary. No,
Yeah.
it's not.
It's a 5
So
page.
I know, right?
no, but okay. So start off by reading. Let's start off with the brief facts of the case. So the company went into creditors' voluntary liquidation. With regard to creditors, the estimated deficiency was 4.4 million. In the meantime, the Secretary of State applied for disqualification orders of the aptly appointed directors of the company, Euro Express Limited, under the act. He also applied for disqualification orders against John Deverell and Peter Hopkins, alleging that they were shadow directors. That is, persons in accordance with whose directions or instructions the directors were accustomed to act, and to whom Section 6 would be applicable by virtue of Section 22(4). Judge Roger Cook, upon applying a strict test to the definition of shadow director, refused to make the orders that were sought by the Secretary of State. The Secretary of State appealed against the judgment of the Judge Cook on the ground that there have been several errors in his observations. Judge Moret reconsidered the facts of the case and weighed them in light of the provisions of the statutes. It was found that both Deverell and Hopkins were heavily involved in the management of the company, and all the major decisions were taken on the basis of their advice or direction. They also took part, though not always formally, in the major financial steps and decisions taken by the company. So Judge Moret declared that John Deverell and Peter Hopkins as shadow directors and reversed the decision of the judge from the lower court. So what were the issues in the case? One was whether Judge Cook had correctly interpreted the definitions given in the statute. Two, whether Judge Cook, on finding of the right facts against Deverell, correctly interpreted and applied the definition to find Deverell to not be a director, a shadow director. And three, whether Judge Cook, on finding of the right facts regarding Hopkins, correctly interpreted and applied the statutory definitions to find out Hopkins was a shadow director or not.
Right. Number three, I think I That was my question.
Okay. So let's move down.
So are they more like
Judgment.
beneficial owners in a sense, Ms. Archer? Or
It
no?
depends. Sometimes it could be persons who provide advice on certain subject matters, and they're invited to the meetings.
Mhm.
And every time they're inviting, whatever it is that they say, the board goes along with it.
Ah, okay. They have influence.
Yes. So the judgment, going to judgment, paragraph 2. Judgment given by Moret L.J. on appeal by the Secretary of State. It was held that shadow director in the general manner to effectuate the intention of the Parliament. The purpose of the act was to protect the public, and given the fact that the statutory definition was being used in different legislative contexts, the definition need to be strictly interpreted. The aim of that act was to bring out those who have actual influence on the directors regarding the corporate matters of the company. These people being someone other than professional advisors. It was not mandatory to show that the influence is being used on all the corporate matters. In light of given facts and evidences, the court had to objectively ascertain whether any sort of communication from a person alleged to be a shadow, be it by words or behavior, was to be treated as an instruction or direction. Even though it would be enough to show that on the basis of those directions or instructions, the directors of the company put themselves in a subservient role and did not exercise any judgment of their own to reach a decision, but acted solely on the direction or instructions of the shadow. It is not necessary to do so in all the cases, as it would put a limit on the extent to which statutory provisions can be interpreted. Because remember now, when we go down a little bit further and I talk about the duties of the directors, you will see one of the main duties of a director is he has to exercise independent judgment. And so if you have a shadow director who has influence over the board, then that means that they're not exercising their independent judgment.
Okay.
Right. The judge, while deciding upon these additional ingredients, laid down certain qualifications that are not mentioned in the statute. Any, quote, non-professional advice also falls under the statutory definition as advice, falls within the concept of instruction or direction. It was further held that to recognize the shadow, it is not necessary that the shadow director should lurk in the shadows and not publicly accept his role as an effective member of management. A person may be a shadow director, irrespective of whether he makes an effort to conceal the part he performs in the company's affairs or not. On the basis of the ascertained facts, the judge held Deverell and Hopkins to be shadow directors and declared them unfit to manage the affairs of the company. So if you look down analysis of the case, the situation before the Deverell case, because there were cases that were tried in the courts in the UK before the Deverell case. And one of them was Unisoft. And then Unisoft and Hydrodam. In Unisoft, that's the second paragraph on the analysis. It said that the shadow director must be in effect the puppet master, controlling the actions of the board and the directors, must be the cats of the paw. And the shadow director, that is, there must be people who act on the direction or instructions of the shadow director as a matter of regular practice. And then they went on to talk about the Hydrodam case. So they said, as set forth in Unisoft and Hydrodam, the judgment adopted a similar reasoning in deciding that, quote, it is important to hold responsible those who have real influence in the company's affairs, but this need not extend to all of a company's activities. So the judgment delivered by Mored L.J. in the Secretary of State versus Deverell proposes a broader understanding of shadow directors, and that was previously required. And this understanding may entail, in particular, instructions given by the shadow director to the board that are not obligatory and therefore do not involve the directors accepting a subservient position. So it doesn't mean that the directors themselves have to be subservient to the directions given. That person can still be labeled as a shadow director. And then they give you the meaning of directions and instructions. And then the pattern of behavior of directors. So they said, going by the statutory definition, the board must be accustomed to act on the advice or instructions of a shadow director. In the Hydro Dam case, it is crucial for the board to not have their independent judgment and act only on the words of the shadow directors. However, in the Deverell case, it is observed that there needs to be some causative link between the directions and the eventual acts of the board. This, however, doesn't mean that the board took a decision which they themselves couldn't have taken based on their judgment, but that they reached that particular conclusion due to the directions given by the shadow directors. That is, the reasoning or motivation behind the decisions came from the direction or advice. And this sets out the difference between the Deverell and the Hydro Dam approaches. In the Hydro Dam case, the directors following or acting on the advice because they consider it proper is not sufficient, but the instructions are given in such a way that they need to be mandatorily followed is what forms the deciding factor. In the Deverell case, directions and advice do not demand that the directors become subservient to the shadow director and surrender their independent judgment, but it is sufficient if the board accepts the reasoning behind the advice and acts on it.
Hey.
So the conclusion, for a company to perform efficiently, the directors of the company need to be efficient and have an independent judgment of their own. When the directors or the board of directors adopt a subservient role and accept every advice coming from a person who is not formally in a position to give advice, those persons need to be identified. The company law often deal with the de jure directors, but the provisions for de facto or shadow directors are mostly absent. However, this case serves to be a landmark case on the issues of identification of a shadow director. This case, though, has strayed from the approach adopted in the previous similar cases, so you're talking about Unisoft and Hydro Dam, has set a clear rule for the identification of a shadow director. This case has changed the view that the shadow director always has to lurk in shadows and has laid down that advice is a part of the terms instruction or direction. And this judgment has thus set clear ground rules for future cases with similar issues. So that's the Secretary of State for Industry versus Deverell.
Hi all, sorry I'm late.
Hi. Yes, we know. Apologies accepted. Okay. So directors normally have what you call exclusive power to manage the business of the company. And the advantage of a board is both the expertise that they bring, the independence from the company's stakeholders, and the efficiency of centralized decision-making. The disadvantage is that directors may manage the company in their own interests rather than the interests of those who they're supposed to manage the company for. So how do you deal with that disadvantage? And you could do that by giving the members or the shareholders more power, And that also has this disadvantage. Or you can assist on certain governance arrangements. And everyone know what I mean when I say governance arrangements?
Not clearly, you could explain.
Okay, so governance arrangement means that you put procedures in place for the board for decision-making purposes. So normally that means that you would do, internally, you would do what we call a corporate governance directive. And that sets out, that governs how the board sets out committees, approves them, the membership of them, how they go about reviewing policies, how they go about following the statutory requirements for meetings. So it's an actual, like a document that they have to follow.
Oh, yeah.
And that's corporate. Now, if they are a regulated entity, you know they would follow the corporate governance guidelines based on the regulator.
Right.
But if you just take the Companies Act or the IBC Act, a company itself can form a corporate governance directive that would settle the procedures for the board.
Right. I think I've seen that, but I never really went into depth of reading it like that.
No, it's a very good document. It's a very good document because then you'll see how the board itself facilitates a meeting and makes this decision. So let's just say if the company had a shareholders agreement and they were going to make a change, let's say they wanted to appoint a new director or they wanted an additional director, the actual corporate governance directive will tell them the steps they need to take to make that happen.
Okay.
So we'll say, check the shareholders agreement, check the articles of association.
Right. Okay.
You'll tell them what to do. Make sure that you get a copy or an updated copy of the proposed director's CV. Make sure you get all of the IDs. Make sure that you meet all the requirements. If it's a regulatory appointed person, make sure that you meet all the requirements and the requirements that are under the regulator's guidelines for approval. It'll take it all, it'll have all the steps needed. So that's the governance framework you put in place to make sure that the board acts within the purview of their powers. Now there's a third option you could do, and that's when you have like agency problems arising. And you normally have this when they are centralized decision-making. Because remember, with a board, there's always centralized decision-making. The chairman would send it out and say, can I have a vote on this? I support. Can I have a second? Okay, so there's centralized decision-making. And so sometimes you have to find a way in wherein there are certain decisions that require more than just the minimum in terms of the board taking a vote. And so you can actually do your corporate governance directives whereby there's a difference in the percentage based on the matters that are being discussed. So in saying that, I've listed in your notes the general director's duties, their fiduciary duty, which we just mentioned earlier before. The duty to act in good faith, to promote the success of the company, the duty to act in accordance with the company's constitution, duty to act in the best interest of the company, the duty to exercise reasonable skill, care, and diligence, Section 81 of the Companies Act, a duty to exercise independent judgment, duty to avoid conflicts of interest, duty to manage the company, and a duty to treat the different classes of shareholders fairly. Now, there's another way in which you can categorize those duties of a director, and you can put them under 3 headings, and it's not in your notes, so you may want to write it down and then number it. 1 you can put them under the heading of duties dealing with the exercise of directors' powers. That's one main heading. And under that, you would put the duty to act within your power, the duty to promote the success of the company, and the duty to exercise independent judgment. So those three would fall under the first heading, duties dealing with the exercise of directors' powers. If you want to, I can type it out and send it to you.
Yes.
Okay. The second heading you can have is a duty dealing with skill and competence and negligence. And underneath that, you would put the duty to exercise and prescribe self-interest. The third heading would be duties dealing with fiduciary loyalty. And that includes the duty to avoid conflict of interest, the duty not to accept benefits from third parties, and the duty to declare interest in a proposed or existing transaction or arrangement. Hence the recent amendments in the Companies Act. Now, I have a question. Where did I write my question I have? Aha. Should I type it?
Mhm.
Yeah, I hear that. Hold on. It's not long,
Okay.
but I'm going to type it. Reply all. I'm continuing on the same string, so everything can be in one place. Okay. While you're looking at the question, I will write the duties over. Okay. And I'm thinking of making this a final exam question. I hear a cough. I hope that's not a COVID cough.
No,
Or is
no,
that a
no,
final
no.
exam.
I was
Or
drinking
that's
water.
a final, or final exam cough.
I was drinking water.
Okay. I mean, the island is so quiet, it's just unbelievable.
You think so?
Yes, man.
Oh,
Today
wow.
is Saturday. People be busy and about.
But it hasn't taken effect till next week, right? Monday, right?
Yeah, but they don't know what's coming next. What I just told you what that man did. Rodney Bunker. He said fear in them people.
Yeah.
He said the fear of God in them people.
He's
Okay,
not to be taken.
I send the question now. Let me send you the duties in the other way.
So the fiduciary relationship would be he has the legal duty to act in good faith.
All the duties.
Not make a profit.
Mm-hmm.
Not place and sell.
Ms. Archie, you sent a question?
Yes, I did.
Okay. Okay. Okay.
see it, right?
Yes.
Okay. Oh no, what happened here? Reasonable. I'm correcting my typos. Does that quiet means that you all are formulating an answer?
Yes.
Okay, wonderful. While I practice my typing. Okay, let me just get the sections in the act. This will be section 81. Companies Act. And where is that section in that new amendment? That amendment to the Companies Act. 20 or 219. Contract, section 25. 107, let me see, section 107. Section 107, Companies Act. Okay, I'm sending it to you now. Okay, there we go. So you see, I've taken the same duties, but putting them under 3 headings.
Oh, okay, this one you just told us about.
Yeah. Mm-hmm. So I'm going to give you some cases that will assist you in answering this question. Okay, so let's look at the first one. The first subheading. There are 3 duties dealing with the exercise of a director's powers. I mean, those 3 duties is to act within their powers, promote the success of the company, and exercise independent judgment. So the first case under duty to act within the powers is the case of, let me see, duties. Percival versus Wright. Think you could find that one on the internet?
Okay.
So that case is talked about answering the question as to whom are the general duties owed or who are their beneficiaries. So we know in common law, the duties of the directors is owed to the company. Only those who are able to act as or on behalf of the company can enforce those duties. The case of Peskin and Anderson distinguish between the fiduciary duties owed by directors is to the company, and that relationship arises between the director and the company, and fiduciary duties owed to shareholders who are dependent upon establishing a special factual relationship. You found Percival versus Wright, 1902.
Yeah.
Okay, so the principle in that case is that directors do not normally owe fiduciary duties to individual members or shareholders. They do not. So in this case, the plaintiffs offered to sell their shares, and the defendants, that's the chairman and 2 other directors, agreed to buy them at $12.50 per share. After completion of the transfers, the plaintiffs discovered that at the time, the board had been negotiating with an outsider for the sale to him of the company's whole undertaking at a price which represented well over $12.50 per share. But this information had not been disclosed to the plaintiffs. In fact, the takeover negotiations ultimately proved abortive. The plaintiffs claimed that the directors stood in a fiduciary relationship towards them as shareholders and sought to avoid the transfers on the grounds of non-disclosure. But the court held that there was no fiduciary relationship between directors and the shareholders individually.
They have a duty to the company.
To the company. Okay, and then it also say you can review the same case I gave you in your notes, Peskin versus Anderson. The next case under that first duty to act within the powers, if you don't like that case, is a case of Coleman versus Myers, M-Y-E-R-S, Coleman is C-O-L-E-M-A-N, 1977, and that's a case out of New Zealand. Tell me if you find it. That also referred to the case of Percival versus Wright.
It's Coleman versus who? Sorry.
Myers, M-Y-E-R-S, 1977, and it's out of New Zealand. Let me see if I can find it. Couldn't find it?
Find it, but ain't nothing coming up like.
And then
I see Coleman versus Myers. Coleman versus Myers is the case of fiduciary duties. It was held that a fiduciary duty existed between the directors and shareholders. The company was a private company with shares held largely by members of one family who had looked to the directors for business advice. And since information affecting the true value of the shares had been withheld from them, the directors were liable to compensate the shareholders. Basically, the directors are knowingly carrying on business in a reckless trading. Directors have a duty to act bona fide for the benefit of the company. If they did not act honestly to contract the debts for the company, the debt would be paid when it fell due. Furthermore, the directors can be made personally liable for debts of the company. Therefore, the director can lift the veil for their defense to persuade courts that they acted honestly and reasonably. You didn't find anything for Coleman and Myers?
I found something, but it wasn't.
I'll put a tick here to send you this one.
Okay.
I'll find a way to do it. Coleman versus Myers. So that's one I owe you. I owe you Coleman versus Myers. And my next case would be Hogg versus Crampon, H-O-G-G versus C-R-A-M-P-H-O-R-N, 1967. Found it?
Yes.
Okay, so in this case, the directors of the defendant company, acting in good faith, had issued 5,707 shares with special voting rights to the trustees of a scheme set up for the benefit of the company's employees in an attempt which proved successful to forestall a takeover bid by one Baxter. And this was held to be an improper use of the director's power to issue shares, but to be capable of ratification by the shareholders in general meeting. Again, this is about the duty to act for proper purposes and also the duty to act in accordance with the company's constitution. Hogg versus Crampton. Crampon. I don't know why I keep saying Crampton and not Crampon. The next case is Howard Smith versus Ampol Petroleum. Howard Smith versus AMPOL Petroleum. This case was considered to be the leading case on abuse of power. Howard Smith versus Ampol Petroleum, 1974. Privy Council. I remember for the exam, you don't have to know the names. You could just remember the facts. Found anything on it?
Yeah, Wikipedia.
Okay. So this is where Howard Smith Limited, there was a rival takeover offers for all of the shares in R.W. Miller Holdings. They were made by Howard Smith Limited and Ampol Limited. So since Ampol was an associated company, with an associated company, already owned 55% of the Miller shares, there was no prospect that Howard Smith's offer would succeed. But a majority of Miller's directors favored this offer, both because its terms were more generous and because of fears as to the future of Miller's if it were to pass into Ampol's control. Miller's directors resolved to issue some $10 million worth of new shares to Howard Smith. And this served the dual purposes of providing Miller's with much needed capital to finance the completion of 2 tankers and of converting the Ampol bulk ships holding into a minority one, so that the Howard Smith offer was likely to succeed. And in these proceedings, Ampol challenged the validity of the share issue. At first instance, Judge Street found that while Miller's directors were not motivated by any consideration of self-interest or desire to retain control, their primary purpose was not to satisfy Miller's admitted need for capital, but to destroy the majority holding of Ampol and bulk ships. He rejected as unreal and unconvincing the director's own statements to the contrary in the witness box and set aside their allotment, and the Privy Council upheld that decision. That's what your Wikipedia said?
Not at all.
I don't know where Ms. Archers get these cases from the better judgment.
That's your
Okay.
own summary?
Yeah. So I need to highlight that one too.
Yes, ma'am.
Yes.
Howard. Okay. Now, the case that superseded Howard, but not in terms of ranking, because Howard was a Privy Council case. There's actually a Supreme Court case in the UK, and it's called Eclairs Group, ECLAIRS, ECLAIRS Group versus JKX Oil and Gas, 2015.
(2015 or 2013?
15. What you have? You may have a different year, depends on who uploaded it.
Yeah, Google had it uploaded twice for 15 and 13. That's why I wanted to be sure.
No, 15.
Okay.
Now read to me what you have. Let me see if it's close.
I'm trying to make sure this is the right thing.
Okay, hold on. Let me look it up. Let me look it up. Let me look it up. Let me see. ECLAIRS.
Shares that were listed on the stock exchange.
Proper purpose rule.
You have?
I don't think this is right. This says something about Glengarry Overseas versus the oil place as well as Eclairs.
This is to do with
It's in Wikipedia.
Yeah.
You don't see it in Wikipedia?
No.
I in Wikipedia.
Oh, I have it in Wikipedia. Mine.
Hang on. Hang on. Okay, I think this is it now.
And then I have it here under the Supreme Court of the UK. I have it here. I can get the judgment in PDF. Do you want me to send you the judgment in PDF?
Yes.
Okay, because I don't know how come y'all can't find these.
I have it in Wikipedia.
Yeah.
Oh. Let me hear your summary then while I type this up. Eclair. Yeah.
A long read. It's a long read.
Why long?
Oh,
Any
no,
other-
that-
Okay,
I
yeah.
have.
Go ahead. I'm gonna send the case to you.
Okay, this says JKX Oil and Gas PLC, referred to in the judgment as JKX, was an English company whose shares were listed on the London Stock Exchange. It was the parent company in a group whose main business consisted of development and exploitation of oil and gas reserves, primarily in Russia and the Ukraine. The company had been struggling, and its difficulties were reflected by its share price falling to historically low levels. In 2013, the directors of JKX perceived that it had become the target of a so-called corporate raid by two minority shareholders, Eclairs Group Ltd, controlled by trusts associated with Igor Kolomoisky, and by Gennady, well, whatever, and Glengarry Overseas Ltd, controlled by Alexander Zhukov and Mr. Ratskevich. It's a long read, Ms. Archer.
No?
Yeah. I have like 4 more paragraphs to go.
What
That's
else?
just the facts.
Yeah, that's just the fact.
Okay, I sent you the actual case. I will tell you how this case becomes important. Oh, I ran out of space because I have my Companies Act open and I have my amendments open. See if I can find it. Did any of you read the amendments in 2019 and 2020?
We would be discussing class.
Yeah,
Saturday.
yeah. Okay, in the amendments of 2020, no, 2019, the new section 118A use this term with regard to inspection of records by members. And it says that any member or their attorneys can request in writing
Mhm.
to normal business. They can inspect the share register and the books, the minutes, any consents, any extracts that they want to, but they must do it for a proper purpose. So when we would have discussed earlier some cases, there's a case called Mills and Mills, MILLS versus MILLS. And in that case, they discuss what they call the meaning of proper purposes. Because when you say when you request something and you say you're requesting it under your proper purpose, that means that you have the power to do so. So in Eclairs Group Limited and JKX Oil and Gas, they were discussing that same thing, proper purpose. So the board of directors of JKX had the power to disenfranchise shareholders who failed to respond to requests for information about their interests in the company shares. It was not disputed that the power to disenfranchise had been exercised so as to disentitle certain shareholders from voting at the AGM. And so by doing that, they would be securing the passage of certain resolutions rather than for the purpose of enforcing the company's demand for information. So they did it in a way whereby these shareholders would have thought that, okay, I don't need to respond because I don't need any information, but that wasn't the purpose for doing it. At the first instance, the judge held that this is an improper purpose. So the purported restrictions on voting was held to be ineffective. So an appeal was launched. And in this case, they distinguish it from previous cases on the basis that the purported victim here was a victim of his own choice, not as a victim of any improper use of power of the board of directors, since it was his choice how to respond to improper use. So the majority held that the restrictive purposes which had not been expressed in the statute or in the articles could not be implied. And in any event, the proper purpose test would essentially frustrate the purpose or utility of the provisions in question. And the Supreme Court disagreed unanimously that the proper purpose doctrine had a central role to play in controlling the exercise of power by directors. So Eclairs Group, JKX, and Mills and Mills spoke about proper purpose and the exercise of that power by directors. Because whenever directors give instructions, they have to be confident that they are acting for a proper purpose. Another case you could look at for proper purpose would be Rehalt Garage, 1964. HALT, Rehalt Garage. If we look at the next, go ahead.
Can you say the name again, please? Sorry, I didn't.
The last one?
Yes, ma'am.
Okay, R-E, Halt, H-A-L-T, Garage, 1964. So proper purpose is Mills and Mills, Eclairs Group versus JKX, Rehalt Garage. So we go to the next one, the duty to promote the success of the company. The case would be Gentcrest versus Cohen. Gentcrest, REGENTCREST versus Cohen, 2001. Found it? Gentcrest versus Cohen. Let me see if I can find it. REGEN, because I know all you could find on this thing is Wikipedia.
Regent is one word, right?
Yeah, Gentcrest is one word. playing with me today. Do that one either. No, can't find it.
It's coming up, but
Chloe.
yeah,
See, they just gave a summary here. Okay, in Region Crest versus Cohen, Richardson had agreed on behalf of his company, Region Crest, to waive the company's entitlement to claw back a sum from a third party. So when Region Crest went into liquidation, the liquidators, on behalf of the company, sued Richardson for breach of duty. They alleged that he had disposed of the clawback asset for negligible consideration and for an improper purpose. Richardson successfully argued that he had agreed to the waiver for a valid commercial reason and had honestly believed that he was acting in the best interest of the company and in accordance with his duties as a director. So in that case, he actually won the decision.
who won? The
He did,
director?
Richardson. Yeah,
Oh,
he won. Mm-hmm. Let me see if I could find a section where he said it. Okay. The judge said, the position is different where power conferred on a director is used for a collateral purpose. In such sort of circumstances, it matters not whether the director honestly believed that in exercising the power as he did, he was acting in the interest of the company. The power having been exercised for an improper purpose, its exercise will be liable to be set aside. See the Hague case of Hogg versus Crampon. However, it has not been contended that that principle applies in the instant case. Three main reasons for the waiver were identified by the Richardson brothers in evidence. First, the need to retain the services of Mr. Scott and Mr. Farley with the concomitant benefit of their knowledge and experience in seeking to realize the various properties in the Region Crest Group's property portfolio. And in the case of Mr. Cohen, the desirability of retaining his services in relation to the Atrancham site, about which he was thought to have a good deal of useful local knowledge. Secondly, the need to preserve a united board in the face of pressure from the banks and other creditors. And thirdly, the fact that it was, to put at its lowest, questionable to what extent the vendors would be able to satisfy any judgment. And fourthly, the fact that the vendors had made it clear through Mr. Farley that they would not submit to judgment on the clawback claim, but would defend the claim on whatever grounds might be open to them. In other words, they were not going to go quietly. In assessing the commerciality of the reasons put forward by the Richardson brothers, I have to eschew hindsight and to place myself so far as possible in their shoes as of the 5th of September, 1990. In the results, therefore, I have no hesitation in accepting the evidence of each of the Richardson brothers as to his reasons for agreeing to the waiver of the clawback claim. And I find that in voting in favor of the resolution for waiver, each of them honestly believed that he was acting in the best interest of the Regent Crest. So the judge said that they acted in the best interest of the company. So I need to get a copy of that for you too. Since can't find a good one on the internet. Now the duty to exercise independent judgment. What case can I give you for that one? Let's see. Let's see what case is the good one for that one. Fulham Football Club, F-U-L-H-A-M. F-U-L-H-A-M Football Club versus Cabra, C-A-B-R-A Estates. Fulham Football Club versus Cabra. Found it?
Cabra Estates.
Yeah, C-A-B-R-A. 1994.
Oh, wait a minute. Okay. I found a small summary.
Okay, read your small summary. It is small. It is small.
This says football club had football ground on lease. In return for substantial payment, directors of club agreed not to oppose any future planning applications which owners of the ground might make, sought to get out of contract by alleging it was an unlawful fetter of their duty to act in best interest of club in future. It was held the performance of the contract is not of breach of section 173 if director exercise independent judgment when entering into the contract and thus provided, this says D, I don't know who D is, believe contract for benefit of company at the time he entered it, cannot claim later on that contract stops him acting for benefit of company. Here directors entered agreement which substantially benefit the company, thus cannot be said that they improperly fettered their future discretion.
Mm-hmm. So, in my summary, it says, in return for a substantial payment, Fulham Football Club and its directors contracted with the landlords of the football ground, which they held on lease, that they would not oppose any future application to the planning authorities, which the landlords might make for the development of the ground. The directors later wished to go back on this undertaking and pleaded that it was an unlawful fetter on their ability to act in the best interest of the company at any relevant time in the future, and was therefore void. And the Court of Appeal rejected the argument. So this is saying that directors must exercise independent judgment. And traditionally it was expressed as directors must not fetter their discretion. And the duty applies equally to nominee directors who cannot blindly follow the judgment of those who appointed them. Although they may rely on their advice, provided they make the judgment their own. So those were legitimate letters that they made. The next duty to exercise reasonable care and skill. There are a lot of cases on this, and they normally start with the case of rebarrings. I know you all know that case. Rebarrings number 5. Remember the case of Barrings? No, yes, that's a banking case.
We had this before.
Everybody knows rebarrings. No?
1999.
Yes. You want number 5?
Yeah, this comes up for number 5.
Okay. So it's rebarrings case. The next case would be Madoff Securities versus Raven. Could start with those 2 cases.
What's the second case?
Madoff, Madoff Securities.
Oh, that's that.
Yes, that man.
Didn't he die, right? He died the other day.
Did he? You sure?
I thought so. That's the one with the ponytail, too.
There's so many of them.
Yeah.
So many of them.
Mhm.
Okay, I could tell you, let me see if I could see what I could find on Madoff.
That's the Bernie Madoff.
Yeah, that's him.
Yeah. I remember
I
that.
can remember his first name. Let me see if I could find his summary. But this is Madoff versus Raven.
Oh, this comes up as Madoff Ponzi scheme.
Yeah.
He's a fraudster.
Victim of fun.
Mhm.
You on call?
Mhm.
Is that the is worse than I thought?
Mhm.
Versus Raven.
Yeah, Raven, 2013. That case illustrated that directors can legitimately rely on other directors. So where a director fails to address his mind to the question whether a transaction is in the interest of the company, he is not thereby and without more liable for the consequences of the transaction. In such circumstances, the court will ask whether an honest and intelligent man in the position of a director of the company concerned could, in the whole of the existing circumstances, have reasonably believed that the transaction was for the benefit of the company. Directors bring different experience and expertise to the joint exercise of corporate management. Whilst each is required to exercise his independent judgment, he may legitimately defer to the views of those with greater experience or expertise than him. Where there is a director who has a record and reputation for outstanding skill and experience in the company's business activity, his fellow directors are entitled to accord a high degree of deference and trust to his views as to what is in the company's best interests. It would be unfair and unrealistic to expect Mr. Flax or any of the other directors to have done anything other than attach great weight to the views of Bernard Madoff in deciding what was in the best interests of MSIL. To take the view, as Mr. Flax to some extent did, that Bernie Madoff knew best, was not a dereliction of the duty to exercise independent judgment. It was a legitimate recognition that Bernie Madoff's high standing in the financial world reflected a level of skill and experience, which did indeed equip him to know what was best for the company and put him in a much better position to make that judgment than Mr. Flax or any other director. So now you say if you have a composition on the board and there's one person who has a particular expertise in a particular area, there's nothing wrong with other directors listening to that person's opinion based upon their expert knowledge and coming to a decision. That happened in one of the matters with Bernie Madoff.
Which case is this, Miss Woodham, Madoff and what versus?
That Madoff Securities International versus Raven,
Okay.
2013. I'm sure you can remember that one easily. Since you didn't call him by his real name, Bernard, you called him Bernie. So you must know him very well.
Oh,
You know him
goodness.
very well.
Very
okay.
well.
The duty to avoid conflict of interest. The leading case in that is Boardman versus Phipps. You can find that on the internet, I know. 1966, that is the landmark case.
Can you spell that?
Boardman, Boardman versus Phipps, Phipps.
1967?
Oh, yes, ma'am.
Mhm.
We would like to assume that's what this is.
It's not a company case. It's not a company case. But it sets out the principles of conflicts rule. It's a trust, yes. The other case you could use for the duty to avoid conflict of interest is Cook versus Deeks. Deeks. And there's also the case of Peso Silver, PESO, Silver Mines versus Cropper, CROPPER.
What was the name of the case before that?
Cook versus Deeks,
Okay.
DEEKS. That's an old case from 1916.
So actually you can send us a summary of what under each heading A. Because I just been writing all over the place.
Yeah, I'm gonna try and see if I can get some copies made and then scan it to you.
That would be nice, because trying to
Yeah.
find these ourselves doesn't always go too well, as you can see.
Yeah, I could see, yes.
Oh, good.
So I'll try to put these together. But at least in your head, you'll know there's some cases coming.
You say some, it sounds like many.
But we just went through many. We did, let's start from the beginning. We did Percival versus Wright, Coleman
Yeah.
versus Myers, Hogg
Hogg.
versus Cramphorn, Howard
Howard.
Smith versus Ampol Petroleum,
Eclair.
Eclairs Group versus JKX.
Mhm.
Under the second
Rebarring.
duty, we did Regent Crest versus Cohen. Under the duty to exercise independent judgment, we did Fulham Football Club versus Cobra. The duty to exercise reasonable care and skill, we said Rebarrings and Madoff. The duty to avoid conflict of interest, what we just did, was Bodman versus Phipps, Cook versus Deeks, and then Peso Silver Mine versus Cropper. The duty not to accept benefits from third parties, I won't give you a case for that one. And the duty to declare, the case for that is Aberdeen Railway versus Blakey.
Amber.
So I'll have
Can you
to send you.
spell it? Amber. Okay.
ABERDEEN
Oh. Aberdeen.
RLY versus Blakey, BLAIKIE. That case is in for 1854. Should be able to find that one on the internet.
Alex.
So, Ms. Archer, when they have a case where they already set precedent, does that mean that they can't set a new precedent?
No, that don't mean that.
Okay.
No. You'll see where they'll say they overturned it.
Okay.
Yeah,
And then set a new,
yeah, they set a new precedent.
okay.
Yeah, but the precedent can't be set by the lower court. It either have to be the court of the same standing or higher court.
Okay.
So let's take for an example, the constitutional matter that's in the papers now.
Mhm.
So that went to the Supreme Court and it went to where? Court of Appeal,
I did.
but now they wanted to go to the Privy Council.
Right, okay.
So in the case of Aberdeen Railway versus Blakey brothers had agreed to manufacture some iron chairs for the railway company at $8.50 per ton. And they sued to enforce the contract. The railway company pleaded that it was not bound by the contract because at the time when it was made, the chairman of its board was also the managing partner of Blakely Brothers.
Conflict.
Yeah. And this plea was upheld by the House of Lords. They said it was a conflict. So that's a good case for you to read.
Yeah.
It's a very good one. So if you're looking at that, I mean, there are many other cases, but we'll stick with those couple right there. I'll see what else I could this week put together for you to read. So if you go back to your notes, on that same page where we were, directors as fiduciaries, more just below the middle, must exercise their powers prudently and properly and act in good faith, not just in the best interest of the company, but also in the exercise of their powers, corporate, discretionary, administrative, and otherwise. They have to exercise their purposes, their powers for proper purposes. And I know you know the case for proper purposes. The case is directors must be seen to be exercising their discretionary powers independently and fairly in all matters, particularly those involving their shareholders and in contractual relationship with external and internal partners. Then I give you another case here which establishes that directors do not have a duty not to place themselves in a position of conflict in and of itself. They should not place themselves in the position where their personal interests or duties to third parties conflict with their duties to the company. And they may have consent in the articles of association, or they can get it by the ordinary resolution of the company. And of course, we know that they're prohibited from gaining any profit. And we know that they have to treat all of the shareholders fairly in the proper distribution of dividends. So in exercising their powers, they don't have unlimited powers to run on behalf of the shareholders, to run the company. They can only exercise the powers that are given to them in the articles or the shareholders agreement. And the ambit of a director's authority is restricted by the Act, the Companies Act or the IBC Act, and the Articles of Association. And the articles usually entitle the board to delegate powers to individual directors as considered appropriate. But they always have to act collectively as a board to bind the company. So director's liability, any breach of any of the duties of their fiduciary duty will amount to a breach. A director cannot be liable for any fraudulent, criminal, or bad faith acts of his co-directors if he has not taken part in such acts, or if he doesn't have any knowledge or any suspicion of them. If he is involved in such acts, however, he is jointly and severally liable with his co-directors, and he may be required by law to make good the whole loss with a contribution from his co-directors, except where monies were misappropriated for his sole benefit, or where there would be no contribution by his co-directors. Directors are also liable to account for any secret profits that they may have made, and the company is entitled to void any contract it may have made with them. Any company property that a director may have taken or transferred to a third party may be recovered by the company, except in the instance of a third party, the property was taken in good faith and for value. A company may, by ordinary resolution, waive a breach of duty by a director, and a court has the power to grant relief to a director who has acted honestly and reasonably, and who, in review of the facts of the case, ought to, in the circumstances, be exonerated. So remember, I told you at the beginning when we started, once you are appointed as a director, the corporate secretary would provide you with all of the requisite documents to act in that role.
Yeah.
And one of them is you got to make sure you have insurance and you have indemnification. So normally what they do is they have a policy, an insurance policy that covers directors' liability. So for indemnification, many directors seek protection from liability and risk exposure from their companies and its insurers within the legal limitation imposed by the statutes. So under the act, it allows a director and his legal representatives to be indemnified by the company against all costs, charges, and expenses which may reasonably be incurred in him in respect to any civil, criminal, or administrative action or proceedings which may be brought by a party.
Ms. Aja, do
Uh-huh.
they feeling on how much they cover? The insurance companies.
What
Does
you
that-
mean?
Particularly with the Madoff case, I mean, it was what, I don't know, that specific one, was that in the billions? Like, okay, say a director messes up and his suit is for $300 million. With the insurance company saying, no, I'm only covering 100 million.
Okay, yeah,
Oh, you mean like
limitation on
that?
it.
Okay. So it depends on what the company purchases.
Okay,
Right. So the company purchases the coverage that it needs, and there's always a maximum.
okay,
Yeah, it covers up to a certain amount.
okay.
Mhm. So the statutory right to indemnification is only permissible to directors and their legal representative, provided such directors acted honestly and in good faith and in the best interest of the company. So it's up to the director to be able to prove that whatever they did was in good faith and in the best interest of the company and not in self-interest. Where they had reasonable grounds for believing that their conduct was lawful in the case of a criminal or administrative action or proceedings involving a company's company that is enforced by a monetary penalty. So in most instances, that is what the director would be proving to the court, that they acted in the best interest of the company and not of themselves. So since directors and officers may be personally liable to any party that may have an interest in the affairs of the company for damages or legal costs and expenses, many of them seek the protection of directors and officers' liability insurance. And these are designed to protect the director or officer against claims that may be made by a company, shareholders, or creditors. So a company may purchase and maintain insurance for the benefit of a director against liability incurred in his capacity as a director. Section 58 of the Act also allows a company incorporated under the IBC Act to purchase and maintain insurance for directors, registered agents, officers, liquidators, and any person who acts in the capacity as a director or registered agent or officer. So notwithstanding the provisions and the protection of directors and officers' liability, it is important that executive and non-executive directors ensure that they are properly and sufficiently covered when agreeing to accept and act in the capacity as a director of a company. You as a director, you have to make sure that you know what your coverage is. What incidents are
Can you take out a
included?
personal insurance?
Normally you don't.
Okay.
Yeah.
Can you?
Yeah, but if you take out a personal, I guess you can, but then that's going to be when the court decides that you are personally liable.
Mm-hmm.
But in most instances, you're going to fight to say that whatever you did was in the best interest of the company.
The
You don't
company.
want to be personally liable because you won't be able to be employed anymore.
Yeah.
So people think that rather strange that you'd want your personal coverage.
Coverage.
Yeah. So prospective and newly appointed directors, they're advised to seek independent advice and review of the indemnification and insurance coverage. Because you want to make sure that whatever coverage there is adequate for what you're going to be doing with the company and the business that the company is in. So you're looking at the extent of your coverage. And then what protection you have against claim and proceedings. And you're also looking to see the extent that it is covered after you demit office. If something happened during your time and the company is being sued, whether your coverage continues after you have demitted office. So
Mm.
since directors and officers cannot rely for protection on the separate legal personality of their companies, as enunciated in Solomon versus Solomon, and protections provided for the company's assets in respect of reimbursement of officers and directors, indemnification and insurance coverage should be a primary consideration in the exhaustive list of requirements of a company before accepting to act as director. The increasing number of claims of shareholder and creditor litigants, the rising cost of litigation, and the personal assets of directors may be at risk. And so you always should encourage the companies and directors and their relevant advisors to work collaboratively with audit and corporate governance committees to ensure not only compliance with internal legal and regulatory requirements, but also sufficiently comprehensive legal and financial protection, particularly for directors and officers who maintain the gatekeeping role, risk, and responsibility of the company. Now you have officers. The general statutory duties do not apply to managers who are not directors of the company. Note that the court doesn't distinguish between the actions of the director as director and actions as managers. Whether director is an executive, these duties will apply to both aspects of the director's activities. Some actions by senior managers of the company, provided that they're also directors, are subject to the same control of general statutes. So officers carry out the operational and daily mandate and activities of the company and oversee the supervision of critical normally report to the board.
So back to the insurance part, does that that's for all companies, right? Whether they have non-profit or active or in any capacity, that the insurance has to be in place as long as there's a board of directors.
Yes, they should have it.
Okay.
Yeah, they should have it. It's a protection. If you are appointed right now to an NGO as a director, that's a part of the questions that you ask.
Okay.
Yeah, what is the encourages, what is the coverage for insurance in the event that the NGO is sued? You need to know your coverage. And then you also need to know what you're going to be indemnified for. In the event that it exceeds, how much will the company pay?
Okay.
So in the act, the IBC Act and in the Companies Act, they speak to officers. They say under the Companies Act, they say the directors of the company may designate the officers of the company, appoint as officers persons of full capacity, specify their duties and delegate to them powers to manage the business and affairs of the company, except powers to do anything except the powers designated in section 103. So the directors, the board of directors, they appoint senior managers, and then senior managers appoint the other staff members. The directors, by resolution under the IBC Act, appoint any person, including a person who is a director, to be an officer or agent of the company. And of course, is always subject to any limitations in the memo and arts or in the shareholders agreement. And then the standard of care under section 55 under the IBC Act says every director, officer, agent, liquidator, and performing his function shall act honestly and in good faith with a view to the best interest of the company and exercise the care, diligence, and skill that a reasonably prudent person would exercise in comparable circumstances. And in the Companies Act, you know, it is Section 81. And then, like you said, it is a fiduciary role for directors, their duties and responsibilities in managing the affairs of the company. The challenges of good corporate governance, increasing shareholders' rights, improper action by directors, and of course, their pervasive legal liabilities of risk exposure to directors for the performance and propriety of companies make it more challenging for directors to clearly define their roles in this changing environment. Because, you know, like we said at the very beginning, one of the things now that the board has to be aware of is they have to meet all of the new environmental requirements. The ambit of directors' fiduciary duties extend also to shareholders, creditors, and employees, making the expectations, the responsibilities, and accountability of directors much greater and more demanding. And these duties are important reminders to directors of their need to be prudent, proactive, and precautionary in their roles as executive or non-executive directors. Because they're always under scrutiny by either the stakeholders or the courts or the public at large. So you can see just being on the board of directors is not an easy job.
Stressful.
Especially, right, especially when you have to go before the courts. Because there's so much that you need to know. And you need to know when you can rely on other directors. If you look in the Bernard Madoff versus Raven, they relied on him because of his expertise, even though he was a crook. but they didn't know that at that time. But that was
No.
based on his known reputation.
Right.
So normally, that's why I'm saying when you look at the scales of the composition of the board, you
Yes.
normally see people tend to lean more towards a person of a particular expertise. So say if you have a lawyer on, or you have a geologist on, and they are directors. And the issue is one that relates to their expertise. Of course, the other directors will be drawn to that.
Yes, yes.
And they would rely on the information that's provided by them. Not necessarily saying that it is true, because Bernie was not that sort of man. Should not have relied upon him.
And so then when they find out that they didn't act in good faith, or they take his advice that wasn't correct, then what happens?
But don't forget now, in that case, the court said that the directors can rely on the person with the expertise.
Right.
There's nothing wrong with that.
Okay.
But at the end of the day, Bernie himself, if the company now wanted to sue him, they can.
Okay.
Because he knew that he was not acting in the best interest of the company. He knew that. But what can the company get? Because everything that he did was fraud. And no, when it comes to fraud, that means there's nothing to put your fingers on. Everything is just an illusion.
Wow.
It's just an illusion. But it is a big responsibility when you act as a board of director for any company. Because you don't know when you're going to be sued by whatever stakeholder. And like I say, times have changed whereby your stakeholder was just saying in the best interest of the company and ensuring that the shareholders or members receive dividends. It's much more than that now.
Everyone now.
It's everybody. It's employees, it's creditors, it's environmentalists, it's regulators, it's everybody. All of them now. You have to be sure that you have enough coverage to handle the risk and taking on that role. And of course, you know, the pay is normally benchmarked. So you can't say you can demand more money because that don't work either. That's a benchmark function. Unless, of course, it's a private company. All right. So that question I gave you, that is how that is answered, by looking at the duties in the 3 subsections and the relevant cases. So I'll try and get the cases to you this week. Yeah. I'll try and put them together so you can read those. And so next week, we're gonna talk about risk. Because all directors need to have some idea of the risk that's involved in the business that they're overseeing. And have a general idea of risk and why it's important. So we'll talk about risk next class. Okay,
Yes.
winding down, almost time for the finals.
Oh, I know.
Almost time. It won't be as easy as the midterm.
Don't do us too bad, Miss Archer.
No, I won't. I won't. I won't.
Miss Archer, have you started looking at the midterms yet?
No, because I was waiting on
Oh.
these same people's names that y'all called today.
Oh,
I said to myself, I said, I don't have all. Let me wait and see why these people have not turned it in.
wow.
So I will get to them this week.
Okay.
Yeah, I'll get to them this week. So
Will we
you'll
be
have your
getting them
results.
back?
Yeah, I'll do them and then I'll scan them back.
Okay, great.
Yeah. Okay.
Okay.
All right. Now I know I don't have to look for 5 of them. I looked at them yesterday, I said, but I'm missing some. Why am I missing some?
That's why.
Yeah, but I couldn't figure it out. I know Kristen, because Kristen sent hers last night, but I said, but she didn't send me an exam. I wonder why. Then I saw she popped it in and she said she's not feeling well. But I thought Nathaniel was still with us. But anyhow, okay, I'll use what I have.
Okay.
I'll go with what I have. All right.
Okay.
So
Yeah.
look out for your cases
Okay.
and read on risk for next week.
Okay.
Okay. All
Yes.
right. So have a good week.
You too.
Yes, avoid the Delta virus, whatever that is, strain.
Variant. Be safe.
Yes. They're advising you wear double mask. I don't know how you're going to breathe.
Oh,
Kill people.
I know.
Yeah, it's very dangerous. It's very dangerous. So just be careful.
Yes.
Yeah. And if you catch anything, let us know.
Okay.
Just so we know not to wait for you in the call. You could just listen to the
Exactly.
recording. Yeah.
Yes.
Because that's what we were doing today, waiting. And if we had known, yeah. Okay, we'll be good.
Yeah.
Okay, so next week.
Okay, Miss Archer.
Okay, yes. Enjoy
Right.
your week.
You too.
We will
Okay.
try.
All right.
Bye, everyone.
Bye.